Then let us discuss about delegation of powers. Okay, so related to your related to the concept of separation of powers is this concept of delegation of powers. Although delegation of powers would be this is more to be discussed in detail with respect to administrative law. The idea of delegation powers can be discerned within the confines of the 1987 Constitution. Okay, so of course, delegation of powers. This is practically a concept where this is tolerated or this is encouraged because remember, if we pass a law, okay, so let's say we have a law that was passed by Congress. Remember that Congress has the power to pass the law. Now, after that law has been signed or enacted, depending if the president would not sign the law, it can be deemed automatically passed. Okay, but let's assume that of course there is already a law. It's already been passed. Of course, the executive department has the role of implementing or executing that particular statute or Republic Act. So what? But right now, if we're going to talk about our laws right now, we have to consider that when our laws are not currently passed and given approval, the provisions of our law seems to be a little bit generic, or the provisions of the law are usually needs this implementation. So it's unlike your example, your revised penal code. Your revised penal code are direct penal provisions in which the judges may directly apply it under their own power, under their own judicial power. So for example, and the RPC is an example of the law which doesn't need any implementing rule or regulation because it can be already implemented or executed. However, there are certain laws or statutes that needed guidelines in order for it to be implemented. Okay, so usually the executive department, or in particular the particular cabinet department that is responsible for such act. Okay, they usually they usually they usually pass an implementing rules and regulations. So the crafting and the approval of such implementing rules and implementing rules and regulations forms part of this power of delegation. Okay, so of course there is this limit as to the power of your delegation. Number one, the first limit of your power of your delegation is it should not rise above the source. If you have heard the Latin term potestas delegata, non potest delegari, okay? It means that the delegated power given to the executive department, you cannot delegate it further, or you cannot delegate it outside the words of the law which it originates, diba? If there is silence in the law, but the executive department decides to pass an implementing rule or regulation which it is not mentioned in the law, that is not permissible. It might be declared or struck down as illegal or unconstitutional because the president or the executive department or the department that's going to implement such the same that measure cannot do so without any legal basis under the statute. Okay, you cannot delegate something out of thin air. Okay, you cannot delegate something out of discretion and out of you leave the delegates unsound discretion in doing so. Okay, then of course the other one would be this concept of permissive delegation. So under our constitution, we have this concept of permissive delegation. So the Constitution itself provides for they provide for mechanisms where delegation may be permitted directly and allowed under the Constitution. So the first one is the permissible delegation on matters in which involve people at large. So we have discussed this on the power of in initiative and referendum under charter change, diba? So when we speak of people at large, it is the direct delegation to the people to propose changes. So they are given the power to propose changes to the constitution, but subject to requirements as may have been imposed in Santiago, Defensor Santiago versus Comelec and Lambino versus Comelec, as we are speaking right now. Then we have emergency power. So emergency powers, this is stated under your Article 6, Section 23. So your emergency, the Congress grants the President emergency powers on situations where there is a need for the president to exercise such power. But there is a limitation. So under the provisions of the Constitution, and this has been already held previously in the classic case of Araneta versus Dinglasan, okay, the exercise of emergency powers of president that is granted by Congress is not is it should be limited as to time. Okay, you cannot impose an emergency power which would last in perpetuity or forever. There should be a time limit or a reasonable time to end such such declaration such you know such declaration or imposition or declaration of emergency powers. So if you can recall, 'di ba, yung previous pandemic natin, the president proclaimed a state of national emergency. It is then of course Congress passed certain measures, yung mga Bayanihan Acts. But of course the president is also aware that it's just to be for a limited time. So 'di ba tinapos na nila yung state na yon, 'di ba? We cannot be in that state of emergency forever, okay? Then we have tariff powers under also the legislative department. So there is a delegation on the part this there is a permissible delegation on the part of the executive department to implement tariffs, customs duties. Then we have these administrative agencies. So when we speak of administrative agencies, so this is what we're discussing. So we have this concept of subordinate legislation, the power the of the executive department, its departments to create implementing rules and regulations. So dalawa yung purpose niyan bakit kailangan i-implement. Number one is of course to fill the gaps, because not everything, as I said, not everything can be tackled by the statute, because it should be flexible. It should be applicable, or Congress may the executive department from time to time may be able to adjust certain measures so that they can they can keep it up tuned to the changing time. So hindi naman pwedeng permanent. Siyempre, example, if your law was passed years ago, di ba? For example, let's give for example si Salary Standardization Act. So this Salary Standardization Act was implemented this was passed in 1989. Siyempre, if you read your salary standardization law, puro mga less than 5,000 lang yata yung sweldong naka-indicate doon, 'di ba? I mean, it's a very minimal amount. Of course, may nakalagay doon sa salary standardization law ng adjustments that allows the president to adjust the salary for every few years. Okay? Kaya nga napapansin nyo, nagkakaroon lang ng proclamation or executive order ang executive department with respect to the movement of salaries, 'di ba, sa government. So, 'di ba, nagkaroon ng movement previously. So, hindi ko alam kung magkakaroon ulit ng ng panibagong adjustment sa salary standardization, but recently it has moved a little bit, and I think the salaries has kind of increased. Okay, they kind of increased, and it can be comparable now to to your entry levels, even in other private endeavors or entities. Okay, all right. So then, of course, finally we have the local government. So I think under the provisions of Article 10 of your Constitution, it provides for a mechanism on local government. So one of the sections there, one of the provisions there allows this delegation of powers, okay, emanating from the local government units to exercise their powers under the local government code and other related statutes. Okay. Then we have this test for valid delegation. So of course, as we have mentioned, we have this maximum potestas delegata, non potest delegare. You cannot invoke, or you cannot implement or exercise a power with outside the confines of the statute. Parang sabi ko nga minsan sa other classes ko, the spring cannot rise above that source. Okay? It cannot be more powerful than it is what it from where it originated. Okay? Of course, kung we have this concept, what now? Diba? How are you going to determine if there would be this situation? Now, the Supreme Court crafted two tests for valid delegations. We have the completeness test and the sufficiency of standards. So, the completeness test mentions that it invokes that the statute should be complete. It should have no room for interpretation, other interpretation, or there would be no room for on the part of the executive to place something or put a gap there. There should the law should be at its entirety be able to provide the necessary definition of what are the scope of powers of the delegate. Okay? This was first initiated in Antangho, People versus Antangho, if you can recall. Then we have sufficiency of standards. So, of course, completeness test refers to the statute, whether it's complete by itself. Sufficiency of standards, the presumption here is that, of course, the statute may be complete by itself, but the next question is, does it comply with the standards as may be dictated? So, when we speak of standards, it would more or less depend on several factors. So there would be many cases that would decide that, well, if the standard is for police power, or if the standard is for the general welfare, or it is for further enforcement or implementation, which is very much necessary for the state, that can be considered as sufficient standards in order to uphold such delegation to be valid. Okay? All right, so let's look at some of the cases. So we have ENOT versus Intermediate Appellate Court. So this is about Executive Order 626 and 626-A. This involves the confiscation of carabaos. Okay, confiscation of carabaos because of suspected diseases. So the provisions of Executive Order 626-A was questioned because it would appear that the the government here, particularly the animal inspection officers, okay, would exercise their powers as if they have this unbridled discretion. Kung nakalagay kasi dun sa executive order is, if they confiscate the carabaos, they can act as they see fit as to what to do with the carabaos going forward. So, di nyo alam, kinatay niyo yung kalabaw or minasaker ng di maganda, ng inhumane modes, or di natin alam, binenta ulit as cara beef, di ba? May mga ganong mga factors eh. Pero of course, you'll create this impression that, well, what are they doing with this? Why are they exercising a very much confiscatory act? Okay? So, anong sabi ng Supreme Court dito? So, they struck down the provision as violative of the the test on delegation of power. So, sabi ng Supreme Court here, the phrase may see fit is an extremely generous and dangerous condition, if condition it is. Well, it is laden with perilous opportunities for partiality and abuse, and even corruption. One searches in vain for the usual standard and the reasonable guidelines, or better still, the limitations that the said officers must observe when they make their distribution. Well, there is none. Their options are apparently boundless. Who shall be the fortunate, the beneficiaries of their generosity, and by what criteria shall they be chosen? Only the officer's name can supply the answer. They alone may choose the grantee as they see fit and their in own exclusive discretion. Definitely, there is here a quote unquote roving commission, a wide and sweeping authority that is quote unquote not quote unquote canalized within banks that keep it from overflowing. In short, a clearly prolificate and therefore invalid delegation of legislative power. So it was declared that the challenge measure, Executive Order 626, is an invalid exercise of the police power because the method employed to conserve the Carabaos was not reasonably necessary. Okay. Then we have Lagman versus Executive Secretary. So this refers to the challenge against Republic Act 10149. So this is your GOC. This is the GOCC Act, yung the law that regulates government-owned and controlled corporations, and this also includes the creation of the Governance Commission for GOCCs. Okay, yung GCG na tinatawag natin ngayon. Sabi ng Supreme Court, the law itself passed the completeness and sufficient standards test despite the petitioners questioning the said law. The abolition or organization was already determined kasi in the say law because they're questioning on the abolition or the creation because the law would now regulate those GOCCs at the same time. They're now going to regulate the creation of such such government-owned and controlled corporations. So the Governance Commission will only determine whether it will take effect in accordance to the policy and standards provided by law. So Section 5A of the said law mandates the abolition or reorganization of the GOCCs only when the following standards are met. So if the functions or purposes in which the GOCC was created are no longer relevant to the state or no longer consistent with national development policies, the GOCC's functions or purposes duplicate and unnecessarily overlap with functions, programs, activities, or projects already provided by a government agency. The GOCC is not producing the desired outcomes or no longer achieving the objectives and purposes for which it was originally designed and implemented, or not cost efficient, and does not generate the level of social, physical, and economic returns vis-a-vis the resource inputs. The GOCC is in fact dormant or non-operational. The GOCC is involved in an activity best carried out by the private sector, and the functions, purpose, or nature of operations of any group of GOCCs required consolidation under a holding company. So this is done in order to authorize to create or do the necessary reforms with the GOCCs. Okay, so delegating the power to ascertain facts, diba, is not an undue delegation of legislative power. So if there is a clear standard that was set by the law, what the Governance Commission for GOCCs will do is just to implement the law. So the said law was upheld to be would be a valid law. Okay, it is not unconstitutional. Okay, then we have Belgica versus Executive Secretary. So this refers to the question as to the local government support fund. So Supreme Court court held here, it also upheld the that local government support fund as indicated in the 2014 General Appropriations Fund. So with respect to the first test, it is easily discernible that the local government support fund satisfies the completeness test. It is clear from the 2014 General Appropriations Act that the policy consideration for the institution of the LGSF is genuine local development and the assistance of LGUs. While couched in general terms, this policy consideration sets forth the purpose for which the LGSF should be carried out. To be sure, the court has recognized the validity of similarly worded policy considerations as public interest, justice and equity, public convenience and welfare, and simplicity, economy, and welfare. With respect to the second test, contrary to the argument of petitioner, of course, the President is not granted unfettered and unabated discretion in disbursing the LGSF. The said GAA provides adequate guidelines and limitations to map out boundaries of the executive's authority in disbursing the LGSF. On this score, the court finds the 2014 GAA contains sufficient limitations that prevent the executive from running riot in disbursing the LGSF. Okay, it's thereby satisfying the sufficient standard test. Okay, all right. So of course, if we have to determine, of course, just look if there is a sufficient standard when it comes to So usually the sufficient standard will be for simplicity. It is the usual things that the Supreme Court would find such implementing rules as permissible delegations. Usually, you would always see it as general welfare. You will always see the reasoning for general welfare. It can be for simplicity. It can be for other reasons that may be given credence. Okay, but the absent that the same might be that might be an unpermissible delegation. Okay, of course we have to discuss also in relation to delegation of delegation of powers is, of course, we have this concept of fiscal autonomy. Okay, so when we speak of fiscal autonomy, it refers to the power of an office to generate its own income. Okay, it is a power to generate its own income. Now, fiscal autonomy should be usually clear from the statute in which that office is invoking. Okay, so for example, we know the Supreme Court has fiscal autonomy. It is clearly stated in your constitution, in the constitution, diba? So the Supreme Court has the power of fiscal autonomy. It has this power to generate its own income other than that of the budget being provided to them by Congress. Okay? So how is it manifested? How would you see that? How would you see fiscal autonomy in action? If you are aware in courts, diba, the courts usually imposes fines for contempt, or if you are late, postponement fee. Then of course this is then other reasonable collectibles. So if you're in the court, you might have heard the collection with respect to Judiciary Development Fund, or the collection on Sheriff's Trust Fund. These are allowed. The Supreme Court or the judiciary is allowed to do so because they have fiscal autonomy. Okay. Now, with respect to laws, it should be also clear in the statute. So right now, for example, I'll give an example. The Securities and Exchange Commission, before the revised corporation code, they do not have this direct authority to issue fines and penalties. Okay, they can only sanction on certain aspects before. If I can recall BP 68, that law is limited as to the SEC doing its corporate duties and functions as an office under the Department of Finance. But with the passage of the revised corporation code, the law provides for certain aspects there where the SEC can impose administrative fines. With that, it would appear now that the law now allows the SEC to exercise fiscal autonomy with respect to this imposition of fines and penalties as may be provided by the revised corporation code. So, hindi na siya purely penal kasi dati sa BP 68 do sa dating Corporation Code of the Philippines, limited lang sa penal provisions. Then there are certain aspects like yung, if you can recall, 'di ba, yung inspection of books and accounts, 'di ba, or accounting, that can be filed in court. But nowadays, the SEC has several mechanisms in order to impose necessary fines and sanctions against corporations because they have already these powers that would be akin to fiscal autonomy under the revised corporation code. So syempre if there is a clear statement in the statute or there's a clear statement of possible administrative sanctions, it would reflect it would reflect that the law would allow fiscal autonomy on the part of that agency or that office that is relevant to such law or statute. Okay?